Welcome back, everybody, to our studies of the law of contracts. In this lesson, we're going to continue to talk about the idea of the offer and the acceptance of a contract, and we're going to focus on this idea of acceptance by conduct. Now, we've been focusing on the idea of the offer for a contract. We've spent quite a lot of time delineating, for example, between an offer and an invitation to treat, talking about the communication of an offer, highlighting things like the postal rule, for example, and then also talking about what happens when a negotiation takes place, where you may have a counter offer, and the commercial context for counter offers, which exists within something known as the Battle of Forms. Now, we've then also started talking about acceptance, how acceptance is to be understood and established, and then also talking about the various different instances and processes by which acceptance takes place. This lesson is going to focus on one of those instances, talking about acceptance by way of conduct. Now, the question that we should really answer, first of all, is could conduct be a valid form of acceptance? When somebody offers you to contract, and you want to accept, do you have to make it very clear and expressly intentioned that you are accepting? Or does your conduct, your performance of the contract, in and of itself represent something of an acceptance? If you have a contract with somebody or an offer that is sent to somebody for you to perform a certain action, and then you go and perform that action, does that represent something of an acceptance of that offer and therefore validate the contract in and of itself? Well, while the general rule in contract law is that agreement can be valid if acceptance is made through express communication, and is really the gold standard if we're going to talk about trying to identify the acceptance of an agreement, it may also be inferred through the conduct or the performance of the offeree. So if you perform the obligations that you are contracting to essentially perform, if you, as a result of which, essentially perform what you are being offered to do, and that conduct is validated and is communicated, then this could infer that you have accepted the contract. Now, there are some cases that we can really think to that illustrates this point in quite a significant way. The 1877 case, for example, of Brogdon versus the Metropolitan Railway Corporation does this and highlights this idea in more detail. So the defendants in this case were the suppliers of a railway company. The railway company were the claimants. Now, they were the suppliers with coal, and they would do so without there ever being a formal contract in place. So there was sort of this general agreement between the two parties that the defendants would supply the claimants with coal. They would supply the railway company with coal. Now, despite the fact that there was no formal contract in place, a draft contract was originally sent by the claimants, but no real formalities had taken place. So there was a draft contract in the mix in and around this particular relationship. And so, as a result of which, the process went on for upwards of 2 years. And then when the defendants then decided to cease the supply of coal to the claimants tried to sue for breach of contract. Their argument was that there was a draft contract which was sent, and while there was never a formal acceptance of the contract, and there were no formal negotiations of the contract, and no real formalities in place, the fact that the defendants had performed the obligations of the contract by supplying the railway company with coal represented and infers an implied acceptance by way of conduct. And this was something which was agreed upon by the courts. There was indeed a contract, the acceptance of which was stipulated by the conduct of the defendant, and the defendant was, as a result of that, in breach of contract by ceasing to supply the coal to the railway company. So it was found that where there is a draft contract, that we have in this case here, and the parties have acted upon the terms of that draft contract, they can be bound by the contract. It is said to be representative of an acceptance by way of conduct. And so this really gives rise to a number of interesting points, specifically relating to the various different methods of acceptance that can be issued. If the offerer stipulates a specific method of acceptance, this may be enough to negate the validity of the contract if that said method isn't adhered to. So if there is a contract in place and within the contract there is a term that says that acceptance of this contract specifically has to be done through a written response, for example, or through a specific action, some kind of specific method that you do to accept the contract, and then instead of doing that method, you go about just performing the action, then it might be the case that you can negate the validity of the contract because the fact that it was not accepted in the method that was stipulated suggests that the individuals cannot be bound to it. Now, there may be an indication that the specific method is a requirement. If the offerer, for example, only wants a return by email, then this may negate the validity of a contract. And so the method of acceptance is quite important. If the method of acceptance isn't stipulated, it isn't specified, then the conduct of the parties in returning their obligations and performing their obligations under the contract may be enough to validate the contract by way of acceptance by conduct.